What are the key factors to persuasion?
Well, I think the three factors are really believing in what you're trying to persuade, really believing in what you're trying to persuade, and really believing.
Complete knowledge of the facts, the law, and the overall circumstances leading up to the arbitration. Is it a matter of public interest? Is it a matter of spreading public view? And so on. Secondly, to demonstrate to the arbitration proceed that the position your client is taking in this arbitration has integrity and is fair. That ability to communicate that is very significant. Your position should not be unfair at the very outset. It should be a fair position. And thirdly, in communicating your approaches to the arbitration, your personality, your integrity, and your sincerity as being an advocate should be clear to anybody who listens to the advocate process.
Well, I think the key factors, or several of them, are be yourself. Just be yourself. Don't copy somebody else. What you do well is what you do well, and what they do well is what they do well. But don't be a phony and try to buy into somebody else's cleverness. And sincerity. I mean, and that's part of the sincerity thing. I think the court and the jury has to believe that you believe in your case. You believe in your cause, and that comes across. Not so much what you say, but the way you act. I think that seems to be what convinces me when I'm on the other side.
The three that come to my mind, and they're all interrelated. Select your themes. Try to hold them to not more than three. Make them simple, make them reasonable, and make them memorable. That's the first thing. Then the second thing is use the themes. A lot of people, they state their themes in an opening statement and then forget about it. The way Beethoven wrote symphonies, he would use a theme in the beginning, then he'd develop it, and then he'd recapitulate it. Trial law is the same way. Beginning, middle, and end, work your themes. And the third thing, again related, is don't do anything in the trial that in your own mind you haven't said, how does this tie to my themes? So don't just put documents in because you have them. Put them in because they tie to your themes. A cross-examination that is short but focused on themes is a lot better than a long cross-examination with 5 gotcha points but doesn't tie to the themes. So those are the three things.
Mr. Smith? Nice to see you.
From my own experience, persuasion works best for me when I try to not be aggressive. I do better, I think, from a jury standpoint when I've backed off somewhat and I'm not coming on strong, either cross-examination or in jury argument or in voir dire. But I think to some extent lawyers have to make up their own style, and I think that's what works best for me.
To me, it's being able to see and deal with the other side of the case, so you know how to grapple with the issues. I think part of persuasion is also being sincere in the courtroom. And I think lastly, and I heard this preached when I first started practicing law, be yourself and be humble. I think that pays dividends.
Honesty,
communication skills, and again, brevity.
How do you persuade someone?
I'm trying to think. I get an opportunity nowadays to interview jurors after the case, and what is persuasion? You know, it's hard to say. I think there are a lot of factors in persuading a person or a jury to accept what you're arguing. But again, I think it's believability. If they believe that what you're telling them is true, most likely true, I think you've got to sell that to them. Sell believability.
Great.
Well, persuasion is, of course, there are wonderful books written about persuasion, but I still say the best of them all is Aristotle's rhetoric. And in Aristotle's rhetoric, all the things we're talking about are touched with the thoroughness that only Aristotle can summon. But in persuasion, you have those things, the exordium, the first speech, where you have your here is the fact, people to be persuaded, get a general picture of what's to be done. The next is to render those facts in an understandable way, and that is a clue. It's your audience you're concerned with, not yourself. And that's a very remarkable thing. By remarkable, I mean something to keep remembering. The next thing is that when you lay out your facts, the expository part of it, assemble them in an understandable way and avoid what's extra, recognizing that human ability to understand is limited. All of us are. It's not a question of intelligence. Only take one thing at a time. So make sure you put together the essentials and stay away from the non-essentials. Once you have the facts, and you've done that by your hard work, then you move in to persuade. And you try to reach the jury or the judge, the audience, with things that would motivate them to come and adopt your position. So you must always be not thinking of just your own performance, in fact, putting that behind you and thinking of the people that are listening to you.
I guess an ability to communicate. And Mr. Ryan and I guess Mr. Barton's going to follow me, both exemplify that characteristics. You need to be able to understand your audience, to be able to talk to them. I think you have to want to and enjoy speaking to a jury. It's something that I think most trial lawyers look forward to, is standing up and looking at a jury, looking at them in the eye and saying, here's what I think, here's what the facts are, and to let them know that you are trying to help them understand what this case is all about.
I think all of persuasion is a footnote to Aristotle's rhetoric, logos, pathos, ethos. And in my judgment, that ethos really, when welded with pathos, accesses this idea of personal authenticity. And that is the turbine or engine that makes an effective advocate, i.e., someone persuasive. Persuasion's an effect.
Well, I think first of all, you have to be prepared to persuade somebody, but beyond which is a trait of a good advocate. I believe that in order to persuade people, you have to convey to them that you're telling the truth, that you're an honest person, that you're not pulling the wool over their eyes, that you're not overselling something to them, and that you back up what you're telling them. In other words, when you make an opening statement, that your evidence follows what you told them, and when you wrap up the case, you're only telling them what you've proven and not sort of going over the line, which again goes back to being ethical.
I have always felt and still do believe that trustworthiness is at the very top of the list. If the judge or the jury doesn't believe you're trustworthy, you're going to have an awfully hard time persuading them of anything. Secondly, I think good communication skills, whether it's in writing or oral, both are extremely important. The skill that enables a lawyer to make something that appears to be complex quite simple, that's a tremendous skill. And Lastly, I think in my way of thinking, there's a quality that I have a hard time naming, but I'll call it sensitive insightfulness that enables a person to perhaps almost intuitively sense what others' values are. Because I think it enables you to know your audience and enables people to connect and resonate on the same values.